Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be talking about what to do if there's an attorney-client fee dispute. And our guest is Elan Weinreb, an attorney in Garden City, very involved in ADR, including mediation, arbitration, and is involved in this program and acts as a mediator in this program. And Elan, this is also available for CLE credit for lawyers, and it may be of interest to clients and others as well. Attorneys should listen for the code at the end of the program, and you might be able to get credit for the Nassau Academy of Law. Elan, welcome back to Law You Should Know.
Thank you very much, Ken. It's a pleasure to be back.
So we're referring to it as FDRP. This is the Attorney-Client Fee Dispute Resolution Program, and this exists throughout New York State.
That is correct. The Fee Dispute Resolution Program is governed by Part 137, and that's a reference to 22 New York Codes, Rules, and Regulations, Part 137, which is a whole set of laws with respect to the resolution of attorney-client fee disputes. It was set up to better give attorneys and clients a more efficient and cost-effective way of resolving their disputes than just going through the court. Primarily, the program is arbitration-based. It does have a mediation aspect in one county that I'm a part of. There may be other ones, but when I trained, and this was 2015, it was only that one county. That would be New York and actually Bronx also, because it's controlled by the two of them. It's considered as one.
And each county has their own way of offering the program or overseeing the program, but these are some general rules that programs are governed by.
That's correct. It's almost like you have a set of rules for the district courts and federal court, and then each sub-district, for example, the Southern District would have their own local rules, which would be different from the Eastern District's local rules.
Or each county might have different rules in the Supreme Court.
Yes.
Anyway, so if at the end of the litigation or during litigation, there may be an amount an attorney feels owed to them by the client. What options does the attorney have at that point?
Well, depending upon the amount that's owed and the nature of the representation, there could be a way of getting into the attorney-client fee dispute resolution program. And the way of doing that is by serving a notice, which is approved by the Board of Governors for that program. And the forms are available online. Let me just give the audience the general website. You could go to www.newyorkcourts.gov. /admin/fee dispute, and that's the general address where most of the materials that I'm going to be mentioning come from tonight. The best way of starting up, and there are actually multiple ways of approaching the Part 137 program, but the most common way is that a dispute occurs and the attorney then serves a notice of the ability for the client to arbitrate, and that's gives the client 30 days. At least is the way things are set out under the default rules. Again, by contract, you can certainly alter things, but this is the most common way that attorneys usually approach the program. They give the notice, and the client responds.
So the first step is for the lawyer to send the letter, and once they send a letter, the client then has a choice whether to say yes and opt for the mediation or arbitration program.
That's correct. And let me just make one clear point about mediation. Mediation is not offered by most of the programs in the counties. It's offered by the New York County system, which is governed by the New York County Lawyers Association. So that's New York County and the Bronx. I believe someone told me, I have not confirmed, that Westchester also offers it. But every other county, you're only dealing with arbitration, not mediation.
Okay. Either way, whether it's arbitration or mediation, this offers several advantages to the attorney and to the client we'll come to in a moment. So what are the advantages to the attorney?
Well, the attorney has a quick, fast, and efficient modality of dispute resolution insofar as he's going to get, or she's going to get, an attorney arbitrator if the dispute amount is under $10,000, from 0 to 10,000, or a panel of arbitrators, where 2 out of 3 are going to be attorneys. In a panel case where you have the amount of controversy ranging from $10,000, really $10,001 to $50,000, they are under the statewide rules. One of the arbitrators has to be a non-attorney, but the other 2 are attorneys. So the attorneys are getting arbitrators who are themselves attorneys, and that's probably one of the biggest advantages. They've been in the game, they know what's going on, and they certainly can understand what the role of the attorney is in the practice and the relationship with the client.
The attorney, and you'll talk in the second half of the program about what attorneys have to do to make the best of their case, but they're going to have to prove their case, and they may be subject to cross-examination and challenge their proof. And the client can bring a lawyer or handle it themselves.
That's correct. And the attorney also, sometimes it's not always that common, but I have had 1 or 2 cases where the attorney is itself a client, where the attorney happened to be someone who practices one field of law, wasn't that knowledgeable, and decided to retain another attorney.
And sometimes they may be advised to, because they're too subjective and too involved in the case to look at things objectively.
Mm-hmm. Absolutely, but sometimes it's also just the attorney wants to do something of their own accord, and that's how you get into that situation as well.
And in general, you may have mentioned before, is there a minimum or a maximal field, that maximum amount of money that's not covered by this program in any variation? Yeah,
the amount, there are a couple of limitations on the program, so I'll start with that one. That's the one which is most commonly raised. If the amount in controversy is less than $1,000, $1,000, or is greater than $50,000, then it's outside of the scope of mandatory arbitration. That doesn't mean the parties cannot contract to have Part 137 arbitrators adjudicated dispute, or arbitrated dispute that's going to be more than $50,000 or even less than $1,000. That I've never seen.
And this applies to business disputes?
Yes. It would apply to any dispute in which an attorney renders services to the client. So I've had cases where LLCs are involved, or other business organizations, including corporations.
Okay. So to the client, this is advantageous. Rather than hiring, an attorney, rather than having drawn out legal proceedings and a bigger legal fee defending the claim, they are able to resolve it in a more economical fashion.
Correct, but there is an important caveat to that. One of the other limitations on the program is that, first of all, there are certain types of cases in which the underlying case we're talking about cannot be handled by the program. Those are going to be personal injury and criminal cases. Those 2 types of cases, if the underlying representation falls into those categories, they are not covered by Part 137. The other limitation, just very quickly to bring this out, because you raised it in terms of being efficient, is a situation where potential legal malpractice or ethics or disciplinary violations are involved. In those cases, you have what's called a substantial legal question. And in those cases, the program excludes the arbitrators from dealing with those issues.
And of course, if the client thinks that there may be malpractice, they can always raise it as a counterclaim if they are sued for fees, and can consult with an attorney about whether there's a malpractice claim and it's worth pursuing. But that's one of the dangers. The attorney opens up a can of worms if they sue, because they open themselves up to counterclaims.
Well, that's correct, assuming that you have a case in which the counterclaims are going to be based upon purely, again, legal malpractice. If the counterclaims in this case would be based on the fee, only on the fee of the nature of that, it's possible to have a case where the attorney could sue, the client could then decide to bring a counterclaim, but then if the options of arbitration would be made available known to the client could decide to proceed on a dual track. In other words, the client, instead of bringing counterclaim in traditional litigation, would start an attorney-client fee dispute with respect to the reasonableness of the fee. And then, of course, if that's the case, then what would be immediately considered is whether or not the attorney violated the rules in terms of Part 137. It's important to understand arbitration under this program is mandatory for the attorney. It is not mandatory for the client, which means that if the attorney brings suit without being licensed to bring it, meaning that, let's say, the 30 days hasn't elapsed yet, and he brings suit, his case or her case can be immediately thrown out of court.
And it's important for clients and, of course, attorneys to be aware of that. So this is a condition precedent for attorneys before suing on those unpaid fees.
Correct. Assuming, again, we fall within the rubric of the program. And just to go through very quickly, the last big limitation, since we were talking about them, the other limitation that applies is a 2-year time period for the performance of services. If the attorney has not performed services for the client for a period of more than 2 years, then the case is taken outside the rubric of Part 137, notwithstanding the fact that the statute of limitations for legal malpractice is usually 3 years and conclusive breach of fiduciary duty, and there are other causes of action where the statute
We're going to come to the hearing after the break, but is there any discovery or anything that takes place before the hearing?
Discovery, generally speaking, is controlled by the program rules, and since the reasonableness of the fee is the core issue which is involved, the discovery really comes down to documents. There are no depositions. There are no interrogatories.
But will there be an exchange of documents? Will the client have to state any challenges they make to the fee in terms of hours or quality of work or anything else? Or will the attorney have to send a copy of the documents they are relying on, fee schedules or hourly
billing sheets?
Sheets, thank you, before the hearing?
Yes, absolutely. The two things that are done before the hearing takes place is that there's a document exchange of everything that led up to the fee dispute. Usually in the case of clients, from my experience, that's been a bevy of emails. Not so much individual timesheets, although if clients have been given timesheets, they are encouraged, not just encouraged, strongly encouraged to submit them. Attorneys, on the flip side, if you are an attorney and you're involved in one of these cases and you do not have timesheets and your invoices, you are in big trouble.
And that's all the more reason you may want to get an attorney to represent you.
That's true.
Any other tips for either the client or the attorney before we move on to the second part of the program? We'll discuss the hearing itself and what the attorney should do to make the most out of the arbitration and what the client can also do to challenge it.
Well, in terms of general tips for both, the attorneys and the clients, aside from getting all your documents in order, I mean, in these cases, the more documents, and when I mean documents, though, I mean relevant documents that you have, certainly it's useful. The other thing that both attorneys and clients should do in both preparation and actually in conducting the hearing, maybe we'll talk about this a little bit more, is focus on the definition of reasonableness of the fee. That's defined from 22 NYCRR, again, New York Codes, Rules and Regulations, Part 200, Section 1200.11, where there are 8 factors which go into defining the reasonableness of the fee.
Do you want to go through them very quickly?
Yeah, sure. So the first one is the time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. The likelihood, that's number 1. Number 2, the likelihood, if apparent, if made known to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. That's basically the lawyer having other commitments. 3, the fee customarily charged in the locality for similar legal services. If you're dealing with lawyers in Manhattan, for example, you're going to be dealing with a different fee structure than you're dealing with lawyers, let's say, out of Nassau or Suffolk. 4 is the amount involved in the results obtained. 5 is the time limitations imposed by the client or by the circumstances. If something is a rush job, for example, then there's obviously going to be a completely different fee structure. Orders to show cause, temporary restraining orders, provisional remedies, all that factors into the nature of the representation. 6, the nature and length of the professional relationship with the client. 7, the experience, reputation, and ability of the lawyer or lawyers performing the services. And 8, whether the fee is fixed or contingent. All of those are the factors which go into determine reasonableness.
Okay, so I can imagine at the hearing, the client, if they can, they're going to challenge the results, the necessary billing, and there may be challenge to what the attorney's ability was in these types of matters.
Yes, and in fact, they do it usually in one of 2 ways. The first general way in which clients challenge is by hitting the results, as you've described. For example, the lawyer was retained to perform task X, and ultimately task X, whatever it would be, getting an immigration visa, taking a case to trial. You fill in the blank, it wasn't performed to the client's satisfaction, or alternatively, the value that was obtained was not commensurate with the billing that for the services performed. The second way that ultimately clients challenge is by line item analysis of the invoices that the attorneys present. For example, a phone call that lasted for 15 minutes is charged at $1,000. Yeah, that's going to be something which a client is going to challenge, and they'll go line item by line item, notwithstanding that the attorney who was involved may have done a superb job and may have gotten, let's say, a $1 million verdict. So that's very important to understand. And
I think you mentioned as another factor the expectations they gave the client or the expectations the client had.
Yeah, in other words, the scope of the representation and what ultimately the goals were and the objectives of the representation, that definitely factors in as part of the results analysis.
Okay. We're going to take a short break. When we come back, we'll continue our discussion with Elan Weinreb about what happens at the attorney fee dispute mediation arbitration. You're listening to All You Should Know on 90.3 WHPC, the voice of Nassau Community College. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, helping both the public and lawyers since 1899. They are the largest suburban bar association in the country. The Nassau County Bar Association offers clinics where you can meet privately with an attorney to prevent or solve legal problems involving Hurricane Sandy, foreclosure, wills, or elder law. Speakers on almost any legal topic are also available to schools or community groups. They can also help lawyers advance their legal careers and offer a place to network. Learn more about the Nassau County Bar Association by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denisi, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking about resolving attorney fee disputes between their clients, especially through the Part 137 Client Fee Dispute Resolution Program. Our guest is Elan Weinreb, who's involved in the program and an expert on it, and also an expert on ADR mediation, arbitration in general. If you've missed any part of the program, it's available as a podcast at nccradio.org, and attorneys can earn CLE credit by listening to the program. Listen to the code at the end. Elan, we've talked a lot about the pros and cons of the program, how attorneys must offer the client the option of going through the program, and they must do it as a condition precedent to bringing a lawsuit. What else would you like to say before we get to the hearing itself?
Okay, so there are a couple of other tips that we were talking about before, which can actually go for both attorneys and clients. Even though most people are going to be listening to this for CLE credit would be attorneys, it goes both ways, and attorneys should obviously be aware of what clients try to do. And if any clients are listening to this, then they'll get the tips from this standpoint as well. So first tip that I have of 3 is that when you're presenting your case, and then this is from my experience as being in a Part 137 arbitrator for about 3 years, remember that generally speaking, pigs get fed, hogs get slaughtered. What that means is that if you're going to try to be too greedy one way or another and try to knock out a fee completely, because again, you're focusing on the reasonableness, you're not going to win. And that goes for the attorney and that goes for the client. So what examples can you have of that? Well, I wrote out a couple of them that have come up before. One, the attorney didn't follow my instructions exactly as I relayed them to him or her and is thus entitled to no fee at all, even though I got some really positive results from his or her services. So if you get a $10 million verdict in your favor in a commercial case, but the attorney didn't produce exactly the type of documents that you wanted, and then you're not giving the fee, obviously $10 million wouldn't be the factor for the fee, but if we're assuming it was a relatively modest fee, yeah, that's not going to work for you. An example from the client side. The client does, I'm saying the attorney talking about the client. The client doesn't understand the concept of minimal billable increments of 6 minutes per task. 3 one-minute phone calls to the client spread out over the course of a day are clearly worth $150. No. 3 one-minute phone calls to the client spread out over the course of the day, you're not going to convince any arbitrator that they're going to be worth $150 combined.
And this is regardless of what any retainer agreement says.
That would be correct. The retainer agreement is obviously construed, but to the extent that the reasonableness of the fee is an overlay, the law is incorporated into every contract.
And especially the value. If they called for a court date or result of something and you weren't there, you're not going to get that kind of money.
That's correct. It's if it's something which
especially if there's a lot of those.
Yeah, and it happens. On the other hand, if there's an emergency or something comes out and there's massive billing for that, then it's going to go the other way. If the client is going to turn around and say, "Oh, I don't really have to pay for that because that's what I originally put down the money for," if the retainer agreement says otherwise, it's going to go against the client in that case. The last example I'll just give you of the pigs get fed, hogs get slaughtered paradigm is communications. The attorney didn't return my text messages immediately after I sent them at 3:00 in the morning. What nerve! And now he or she expects me to pay me, for whatever it would be. The attorney is entitled to nothing over here. No. There's reasonableness again of the fee refers to the reasonableness of the relationship. If you're going to be involved in attorney-client relationships, it's expected that you're not going to be answering text messages at 3:00 in the morning.
And also, if you're going to contact them constantly, they are going to expect to be paid something for that response.
That's correct, and that has to do with the availability of the lawyer and the ability of that lawyer to take on additional cases.
So it's going to go to the value of the communication, which you mentioned earlier. Mm-hmm. So we're at the hearing. Sometimes lawyers bring lawyers, and clients have the right to bring lawyers. Mm-hmm. It's going to take place over one day or evening. It's a one-shot thing.
Usually no longer than 3 hours. Okay. I've never had a hearing that goes longer than 3 hours. The hearing is controlled by Article 75 of the CPLR, insofar as we're dealing with New York State court arbitrations. So, not court, New York arbitrations. And under that article, people have the right to have attorneys present. That right is non-waivable. There is a right for cross-examination. That applies both to clients who are pro se and clients appearing with attorneys, and obviously the attorneys have that right as well. There's a right to present evidence. There's a right to call witnesses. And
are the rules of evidence more or less relaxed?
Yes, the rules of evidence are almost completely relaxed, just like in any other traditional arbitration, unless, of course, the parties have contracted otherwise. It so happens once in a while you get parties who will say that they want Part 137 arbitrators to conduct their arbitrations under the rules of a different provider. It's rare. It doesn't happen very often, but once in a while you have that. If the parties have a pre-existing contract which states the rules of evidence must be applicable, then, and again, I've never seen that, but if they had that, that would certainly be something to factor in as an arbitrator.
So even if the parties had some kind of arbitration agreement, putting aside whether that was kosher, the collection aspect is still governed by Part 137?
In terms of collecting the fee, yes. And the way that it works is that the burden of proof is on the attorney. It's by the preponderance of the evidence for the attorney to prove the reasonableness of the fee. So for people who aren't lawyers, that means that you, as the attorney, or the attorney as the person who's bringing the dispute, has to prove that it's more likely than not that the stated fee was reasonable. And then, of course, there's another aspect of collection, since you mentioned that term. It's not always that you have a situation where the fee is going to be collected from the client. Sometimes you have refund cases where effectively the client is already advance paid out on a retainer, an advance retainer or a security retainer, and then the question becomes whether or not the attorney has to refund a portion of the fee back to the client. So it goes both ways.
And if you started to discuss it in the beginning, but if the client has some kind of counterclaim or malpractice claim, that's not going to be resolved at the hearing.
That's correct. If it's a substantial legal question, and that usually falls into legal malpractice or alternatively an ethics or disciplinary violation, that's not going to be resolved. Clients, by the way, should be cautioned that to the extent they want to use the attorney-client fee dispute program as a surrogate for airing those claims. I've had one or two cases where clients, even though they're told substantial legal questions are not going to be considered, we're looking at the reason most of the fee, nonetheless, they insist that something was done in such a way that they didn't want it to be done or the attorney committed malpractice. There's a problem for clients who end up adopting that route, and that's collateral estoppel. Whatever happens in the arbitration may very well, if it's decided by the arbitrators as an issue, come back to bite the clients later on. They may be precluded from bringing a malpractice action.
And so they should consult with an attorney before they agree to this.
Yes, and one of the things that they should also consider, and this goes both for the attorney and the client, is the availability of trial de novo. It's another aspect of the program, which essentially is that once the arbitrators render their award, unlike other types of arbitration, the award by default is not considered binding until 30 days have passed since the attorney and client have received the award, at which point it was considered final and binding. But in that 30-day period, either the attorney or the client has the right to essentially elect a new trial. That's what trial de novo means, a new trial, and to go forward in traditional court if they're dissatisfied with the arbitrator's award.
And the client or the lawyer can do that?
That's correct. It's open to both attorney or client, unless in the retainer agreement there's been a waiver of trial de novo, and there are very specific requirements for doing that. There does have to be a known and informed consent to do it.
Okay, we only have like a minute left in the show. What other tips do you have for attorneys to be successful at this type of proceeding?
Okay, so this goes to attorneys in particular. Avoid round numbers. If attorneys are going to be presenting the case, again, they have to prove the fee by the preponderance of the evidence. As arbitrators, we like to see very specific numbers and an analysis of that, because it shows the attorneys are not taking some very liberal stances with their bills. They're really giving some thought into what they're charging and the reasonableness of the fee. It goes for clients as well. If you're a client and you're going to be claiming that you shouldn't be required to pay something, don't say $3,900. Say something like $3,984.23. It gives another impression. The other tip for both attorneys and clients, but particularly for attorneys, be very kind to the program and case administrators, as well as the arbitrators. There are times when attorneys have done things which are not particularly kind, such as they spring documents on the arbitrators at the last minute. Not a good idea. If you're a client, you're going to get more leeway, especially if you're pro se. But if you're an attorney and you do that and you expect the arbitrators in the course of 3 hours to resolve these, go through the documents and to crunch them, it's not going to happen. There have been one or two cases where I've been on a panel and the chair of the panel has been confronted with a whole bevy of documents, and he's just said right off the bat, we're not taking them.
And just in 20 seconds, are most people happy with the program?
Generally speaking, yeah. I think I've gotten the sense that most people are particularly happy with the mediation aspects of the program. In the NICLA program, that's what I'm a part of, but also with the arbitration program as well. There aren't that many trials de novo as far as I've heard from the program and case administrator.
So, Jen, just a cautionary note, attorneys and clients, you should just find out in detail about your local rules and what options are available. Attorneys can earn CLE credit through the Nassau Academy of Law. Contact them at 516-747-4070 for more info. And the program code for this credit is BX1980. That's B as in boy, X1980. I'd like to thank our guest, Elan Weinreb, for being our guest and providing so much information about the Part 137 Attorney Fee Dispute Resolution Program. It's a very important program to lawyers and clients. Remember, if you've missed any part of the program or you want to hear it again, it's available as a podcast at nccradio.org. Please join us next week at this same time for another program on Law You Should Know on 90.3 WHPC, the voice of Nassau Community College, and also over the air at nccradio.org.
Before we go,